is not always intuitive, especially when it comes to domestic violence accusations. And so in this video, I'm going to be talking about a misconception that a lot of people have in their domestic violence cases, especially when they've been falsely accused. This is the second video in a series of 7 videos in which I go through the 7 most common misconceptions that I hear again and again, and that, if you believe them, can really hurt you. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And if you are facing a restraining order as well, which a lot of people are when they are falsely accused of domestic violence, and the victim does want to press charges and things are not good with the alleged victim, I also am the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to win your restraining order hearing. So if that is something that you are interested in, you can get your free first class in the course via the link down below. Okay, so let's jump right in. The second misconception that people often have when they are falsely accused of domestic violence, and this is that getting justice against the alleged victim, against this person who is lying about you, is somehow part of the case. Look, how this works when you are a criminal defendant is it is a one-way street. It is the state against you. That's it. The alleged victim is merely a pawn of the state to use against you in the case, and that is whether the alleged victim is on your side or not. There is no getting justice against them. I mean, sure, if you make it all the way to jury trial and your attorney does a really great job at cross-examination, which not all attorneys do, and they may not have enough material to rip the alleged victim apart on the stand. It really depends on what you have and how good of a liar the other person is. Even in that case, and by the way, even if that happens, you could still potentially be convicted. But even if you win, are you really vindicated at that point? What do they care? They leave, they've been treated like a victim, they've been treated so nicely by the judge, by the DA, by the victim's advocate who is paid for them to Uber back and forth or paid for their parking, who's made sure that everything was convenient for them. Meanwhile, you not only had to bond out, you not only had to pay an attorney for the pretrial part of your case, but now you had to pay an attorney to go to trial, which is not cheap. And if you're thinking you're going to do this with a public defender, trial with a public defender should be your absolute last resort when there is no other option for you. So you had to pay a pretty expensive defense attorney to spend at least 2 weeks just on your case. You had to, every day for those 2 weeks or so, and many other days too, you had to miss work, sit there all day, listen to some potential jurors trying to get off jury duty saying, you know what, he looks like a woman abuser. I don't want to be on this case. You're going to have a judge who may or may not be nice to you. You're going to have to deal with a DA who definitely won't be nice to you. You're going to have to deal with 12 random people who may or may not actually really be your peers, looking at you, literally judging you, and deciding your fate. So if at the end of the day they say not guilty and return you back to how you were basically before you were arrested, and by the way, at that point you still have the arrest on your record. You have to get it sealed, otherwise it will stay there for a period of time. Are you really going to feel vindicated then? And another thing is that it's not always going to be part of the best defense strategy to rip the victim apart on the stand. If the victim comes across as very sympathetic, then the best course of action may not be to rip the victim apart on the stand. It might be maybe to blame the police and prosecution, or to say that the victim is confused in some way. It may not be even anything that's necessarily going to make the victim feel bad. And of course, you can insist or try to insist that your attorney take the strategy that they just mercilessly, meanly, savagely rip the alleged victim apart on the stand. But you don't have any experience with this, right? You're watching videos about misconceptions and making sure that you don't have them, and make sure that you watch all of them, by the way, because it really isn't counterintuitive. This is someone who has experience. So even if it is a public defender, you should listen to them because they have seen many cases, they see how these things go, and they know what the best strategy is going to be, or at least they know better than you. They have a better idea than you do. Okay, so let's go through an example of this and how it would play out. Sarah, a single mother, is outraged and frightened because she has been falsely accused of domestic violence by her ex-partner, and she's especially fearful that it is going to impact her child custody if she's convicted of domestic violence. Sarah wants to use the trial in her criminal case to vindicate herself. In fact, when she is offered classes in exchange for a dismissal, she refuses to take it, even after being advised that that's not going to hurt her with custody because she would get a dismissal. She's mad at this point. She wants her day in court. She wants to have the criminal trial, and she wants to use it to go through her ex's dishonesty. And that is what she focuses on. She talks to her attorney and she explains all the times that this guy has been dishonest in the past. So we're going to do, again, a choose your own adventure style and see what the outcome would be. So choice number 1, Sarah focuses on her partner's dishonesty. She collects evidence of all the times that he's ever lied. In fact, she believes he's a pathological liar. She has a good attorney who explains to Sarah that a lot of this is not going to be relevant. Little lies that he told in the past, even if he cheated on her, that is probably not going to be relevant. The attorney keeps trying to redirect and tells Sarah, look, you have a good defense. He was abusive to you. You were just acting in self-defense here. We can use that. We can prove that. But Sarah is adamant. She insists that the attorney, much to the annoyance of the judge, keeps asking her ex on cross-examination not about whether he was abusive and not about the events in question and the fact that Sarah was simply defending herself and that he's just trying to get a leg up on custody here. No, instead, at Sarah's direction, her attorney focuses on the fact that this guy is just a liar in general and focuses on these petty lies. The judge gets so annoyed that he cuts the attorney's cross-examination short, resulting in there not being much of a cross-examination at all on the important issues, and on the issue of whether or not Sarah committed domestic violence. The attorney then puts Sarah on the stand, and again, all that Sarah wants to talk about and all that Sarah talks about are these lies that her ex told her over the course of their relationship. Because Sarah knows that of course she didn't commit domestic violence. If anything, she was the victim. But she doesn't say it. She goes on about these petty things and misses the forest for the trees. Sarah ultimately gets convicted. Now let's say that Sarah makes another choice. Sarah listens to her attorney. Sarah can see that her attorney cares about her case and hears her out about all these lies, but when Sarah's attorney explains to her that, look, some of that stuff might come up, sure, but we need to focus on what's important. Let's focus on the fact that he has been abusive in the past. Let's focus on the fact that you were merely defending yourself here, that he doesn't have any injuries, that he has a motive to lie. Let's focus on that. And ultimately, Sarah wins. Now, the lesson here isn't necessarily just listen to your attorney. There are some lousy attorneys out there. But what is important is that you focus on defending the specific domestic violence charges against you, instead of focusing on the fact that the other side is a jerk or has lied in the past. Yes, sometimes that stuff can come in, but it would be a mistake to focus on that as the main issue instead of focusing on the fact that you are not guilty. And I see this both in domestic violence criminal cases and in domestic violence restraining order cases. It can be really difficult to, especially if you feel like you were the good guy or at least the other guy was the bad guy in the relationship, to focus on, okay, here is the specific aspect that we are talking about. We're not talking about the whole relationship. We're not talking about everything that the other person did wrong, because it doesn't matter. The jury at the end of a criminal case, at the end of a trial, is going to get an instruction, and they are going to be told exactly what they have to decide. And it is basically whether you committed acts of domestic violence. And then if you do have, for example, self-defense, like Sarah had here as a defense, they're going to have to determine whether there was enough evidence put on of self-defense. And if you were focusing on these petty lies and that the other side was a jerk in the relationship, the jury, who, if you're lucky, is only 50% asleep, having to sit there day in and day out and listen to all of this, what they will remember is what the prosecution put on, because the prosecution isn't going to be focusing on petty relationship stuff. They're just going to be focusing on, all right, the police came out, here's the evidence that we have of domestic violence, here are the witnesses that we have that we're going to put on. Okay, and the lesson here is not to just blindly follow your attorney's advice, but to really try to understand what needs to be proven at trial by the prosecution and what can be done to disprove that or to poke holes in that. Because this is a one-way street. If you are a criminal defendant, you are just defending against the accusations by the state, not even by the alleged victim. It's the prosecution who has brought this case against you, and it is them who has the power to dismiss it. And you need to focus on protecting yourself. In this particular example, it sounds like Sarah probably should have taken the classes in exchange for a dismissal instead of going through the stress of trial, and then used her family law custody case to really rip apart the other side. And if she was just defending herself, then maybe even use the family law case to bring domestic violence accusations against him, even if it's not in criminal court, and use that to potentially get more custody or get full custody if that's what is in the best interest of the child. I hope you found this video helpful. Make sure that you watch all 7 of the videos on these misconceptions. These are things that so many people, no matter how educated you are, if you don't have experience in this, will commonly misunderstand because, again, it's not common sense. If you did find the video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, Facebook, and TikTok.